And I put it to everyone present here today, and anyone whose concern is justice, that our company, Kremen Kitchen Tech, founded by my father.
What are you doing?
Oh, I have a lot of things I want to say today. Is it all right if I call the mediator my learned friend?
Donald, we are not going to court. This is commercial mediation, remember? There are no speeches from the dock, no wigs. My learned friend. Come on, we need to go.
So, like, we had 3 vans full of furniture and equipment and 7 employees who had driven 300 miles. They were supposed to be in and out in a week, but couldn't get access to the site for 3 days. Couldn't contact anyone, and ended up hanging around, staying in B&Bs. Our client, the International Institute of Catering, now says we're the reason they let a big client down. You know, the usual. And now, not only have they said we can whistle for the losses incurred due to the delay, they're not paying the second half of the 200 grand they owe us.
We went to our lawyers first. We just got to the stage of issuing proceedings, and it was they who suggested there was an alternative to going to court, commercial mediation. So we decided it was worth trying. When you go to court, obviously there's what the costs might come to, and anything discussed is capable of appearing in the newspapers the next day. And it's the whole thing of not really being in control of matters, you know. It's lawyers and judges that run the show, and I guess that's what Donal and I needed the most reassurance on, that the mediator takes no decisions and doesn't direct anything. He only facilitates a process and tries to get everybody to a place they can live with.
So this is the first time you've seen these guys since that woman was in reception looking for a cheque?
You mean Orla Newell? Yeah. It's all been by letter and through solicitors since then.
Raj, same with you?
Well, I got all the angry phone calls that Dennis wouldn't take, but yeah. And you know what I think? They're a great company to deal with. And dropping them as our suppliers doesn't suit me at all.
Well, you know, I hope this mediation is all it's cracked up to be. I hope we don't regret not letting it go to court.
Seriously, name me one person who regrets not going to court.
Hello? This is us here. Why didn't you sit in the front? Kremen Kitchen Tech have had good business from us and had referral business through us. But they fumbled the ball on this one. We ended up with 40 international students unable to take up their place in the course for over a week. Now, some could fix up their travel arrangements, but some couldn't. And they ended up sitting there staring at each other and obviously grumbling at us because they were left there. But the delay's on Kremen's side, as is our loss of €135,000. But they want their invoices paid as if nothing's happened. And they are going to sue us. I mean, it's crazy stuff. Theirs is the fault. Our solicitor says that we can prove causation on Kremen's part and that we can show they knew by their actions that how they managed their project was going to affect us negatively. We've already spent a lot of money on legal fees. So after months and months of toing and froing, we were persuaded to go down the commercial mediation route. My major shareholder is a skeptic. We'll see.
Change.
Thanks.
I think we've got a good case, but in fairness to our solicitors, they can't guarantee us a result in court. No one wants the publicity around this sort of thing. Our competitors would have a good laugh, and they'd call all our clients the next day. For me, it was the privacy, the confidentiality of the process that swung it for me. And let's face it, no one wants to end up in the witness box. There's also the fact that a wrong result in court could wipe out 2 years' profits straight away. If I've one concern, it's something Tom Reed, the mediator, said. Anyone needed to sign off on an agreement needs to be in the room. Now, I know Jerry won't sign off on anything without his major investors say so, and he's not here. Tom's going to have a problem with that.
Commercial mediation is a private and confidential dispute resolution process in which an independent and neutral third party, the mediator, helps the parties involved in a dispute to reach a mutually acceptable negotiated agreement. The key advantages of commercial mediation are that at all times the parties are in control of the process. It is completely confidential, and commerciality, business sense and experience are applied throughout. Commercial mediation is also time-saving and costs considerably less than going to court. This DVD has been produced by the Irish Commercial Mediation Association, a voluntary non-profit organisation established to promote and develop commercial mediation in Ireland.
Commercial mediation is an alternative route for the resolution of disputes between businesses, and the judiciary are quite clear on that. The courts are not designed to save commercial relationships, for example, and that's just one aspect of an outcome that mediation can deliver over what the courts can. The mediation process involves the recruitment of a mediator, and mediators can work wonders. They can bring resolutions to disputes that are both bitter and long-standing.
In my experience as a commercial mediator, I've come to rely on being a problem solver, being non-judgmental, being an active listener to people, actively listening to what they say, not just hearing it, but actively listening to what they're talking about, what their problem is, to be able to help them to solve that.
As a mediator, I consider myself warm, genuine, aware and calm, and in fact, having a really relentless positive outlook.
I've found that optimism is contagious. As the day goes on, they begin to realize that they get optimistic and they get psychologically committed to being successful in the mediation process as well.
The skills that I bring, I believe, to commercial mediation are professionalism, are persistence and patience, flexibility and adaptability. And all of those, I believe, are necessary in a mediation.
Cases that are suited for mediation are commercial relationships that have been extant to the mutual benefit of both parties over a long number of years, but which have been sundered as a result of a particular incident. If they go to trial in court, things are said in the witness box which are neither forgiven nor forgotten. But if these matters can be thrashed out at mediation, I have seen on numerous occasions a viable commercial relationship being resurrected and going into the future in a way that is beneficial to both sides.
I think if we go to litigation, we're going to end up with people on two sides.
An agreement to mediate is an agreement where you set out all of the terms of the mediation, where it's going to be held, the ground rules of the mediation, the charging, and the confidentiality of the mediation.
On the day of the mediation, at the opening phase, as we call it, I bring the parties together to give them the opportunity, if they like, to tell their own story in their own words to the other party. This is quite challenging for the parties, but it is really, really valuable, because very often it's the first time they've met in quite some time.
What goes on between the parties within the mediation is private. And indeed, within the mediation process itself, you as the mediator may decide to have private meetings with different parties, separate parties. And what goes on in those separate sessions isn't told to the other side. And that's really, really important, because that's what builds the trust and confidence with the commercial mediator.
You must remember that in mediation, it is voluntary. And in order for you to succeed, you have to account for the other party's position. Otherwise, you won't get his buy-in. To keep everybody focused on a positive outcome, I get parties to work in great detail on the alternatives that are open to them should they not settle today. Business understands risk. Very often, the risk of not settling is more than enough to convince a decision maker to settle on a deal that he can live with.
When that signed settlement agreement occurs, I am thrilled. I can tell you that there was one time that I had two parties signed a settlement agreement, and they turned and they faced each other and they hugged each other. It was a thrilling moment for me, and I think the other 15 or 20 people that were in the room to watch that.
The mediation takes place in an agreed location. This can be the offices of one of the parties' solicitors or a neutral venue. What is important is that there be a room each for the parties and a room for joint meetings held by the mediator.
Good morning, everybody. We'll be starting shortly. Jerry, could I have a word with you? Just one, two, three, Jerry, aren't we missing someone? You said your investor would probably need to be here.
Oh, he couldn't make it.
Okay, but I did explain. You're going to need to have him available by phone to give you the okay on any agreement that's drawn up. Can you arrange that now? Or let me know if you can't. Because if he's not available, we're probably looking at calling it off.
No, I can do that.
Good.
I think it's important for people to be focused on problem solving for the day. And so I think we want to set up a comfortable environment and an isolated environment. Typically would do this with a conference room and then a breakout room or a separate room for each of the parties. That way they have their spot where I can speak to them in confidence individually.
Well, welcome everybody. We all know why we're here. And we've all done a lot of preparation work to help ensure that the day will be as productive as possible. And hopefully it'll be one that will allow you all to move on from this dispute and get back to your businesses with the matter resolved. Now, just to remind you, nothing that we discuss here today will become known to anyone outside the process. It is entirely confidential. And this confidentiality exists on another level also. What you discuss with me in your respective meeting rooms is not divulged to the other party, unless you say that it's okay for me to do so. Now, I promise you, I will do everything in my power to bring about a resolution and reach an agreement that you're all happy to sign up to. But you are in complete control. You make the decisions. And nothing is agreed until everything is agreed. Now, as you know, I only facilitate this process. You will be directing matters, making the decisions. Now, I can help you do that. And if you get stuck, I can help you out. But you have got to want me to do that. Well, Donald, would you care to begin by giving us an outline of your position and what's brought you here today?
I mentioned integrity to you.
Many
earlier
but
on,
not
sir.
all mediations start with the parties meeting in a joint session. Here, everyone is introduced. The mediator explains what course the day will take. It is normal for the parties to make a short opening statement to each other in which they set out their position and what they wish to achieve. The decision as to whether or not a joint opening session is appropriate lies with the mediator.
About it. And like you, I wonder if there's any point in us staying here at all today.
Mediation provides a very pragmatic method to get a deal, a commercial deal. That's what it is offered here. And so they need to be realistic, they need to compromise, and they need to assess and recognize that maybe they're not completely right. And I tell them right from the beginning that they need to be thinking about this and have a willingness to consider what the other side has to say. There's probably some merit to what they have to say, and they need to take that into account and not be too overly optimistic, because it's a painful process that will require compromise, and they need to recognize that, and we talk about that right from the beginning.
An important part of the mediators engaging with the respective motivations of the parties is building trust, and helps him to allow each party hear what the other side is really saying. This is critical in preparing the ground for settlement negotiations between the parties in how it allows clarifications of their respective objectives and issues.
That's a problem for us.
We couldn't live with that.
For God's sake, why would we agree to that?
They're throwing their weight around. It isn't fair.